Excellent. Well, hello, my name is Talia Gonzalez, and I'm co-chair of the Committee on Alternative Dispute Resolution and Restorative Justice, which is part of the Criminal Justice section of the American Bar Association. I want to extend a welcome on behalf of our committee and the ABA to everyone joining us for the second in a series of webinars that are focused on restorative justice and criminal legal processes. This program is co-sponsored by the American Bar Association Criminal Justice section and the Dispute Resolution section. Please note no CLE credit will be offered for this program. And we invite the audience to share questions via the chat function if you're joining us here live today, or excuse me, view the question and answer function if you're joining us here live today. We will also check the chat, but it is better to use the Q&A function so that questions can also be answered in real time, both by our expert panelists as well as by myself or others as needed. Before we begin formally, I do want to introduce our guest speaker and make two short announcements. First, on September 20th, we'll be hosting our next webinar and program, which is focusing on pre-adjudication restorative justice models and practices. That will be at 1 p.m. Eastern on September 20th, and announcements will be made available via email and posted on the website. I'm excited to share that webinar is going to be co-led by two restorative justice practitioners, Ames Stetson, who's chair of the Colorado Coalition for Restorative Justice Practices and handles cases through the Inglewood Municipal Court, and Rami El-Hadib, who is the Restorative Justice Program Manager for the Georgia Justice Project, where he facilitates felony cases diverted from the partner district attorney offices around Atlanta. So really giving a breadth and scope to thinking about restorative practices in the field. The second announcement is that I'm pleased to share that at the ABA's Criminal Justice Section 16th Annual Fall Institute, there's going to be a joint CLE breakout session co-hosted by this committee and the Alternatives to Incarceration Detention Committee on November 3rd from 11 to 12 p.m. Eastern in person on restorative practices. It will be a rich and robust panel with panelists coming from across the country. With those brief announcements and logistics, I'm delighted to introduce my colleague and friend, Jonathan Shar. Jonathan, or Professor Shar, excuse me, is the Clinical Associate Professor and Director of Restorative Justice Project at the University of Wisconsin Law School, the Frank J. Remington Center. He has extensive experience as a facilitator of victim offender dialogues in sensitive and violent crimes, and has served as a trainer for multiple years in a variety of restorative justice practices. He is deeply involved with the work in Dane County and will certainly potentially reflect on some of that. I do want to highlight the Restorative Justice Project at the law school has facilitated over 100 restorative justice dialogues and served more than 200 harmed bodies as part of this process in just the last decade, and those numbers are probably outdated as of today. So I just want to say thank you for being with us today, Professor Shar, and I turn it over to you now.
Yeah, well, thank you very much for having me. I'll begin sort of screen sharing here. And just as a note, again, once I sort of go into this mode, I won't necessarily see the Q&A. So again, please, if there's any sort of need to, sort of interrupt me, and I'm happy to discuss things further as we go along. Okay, so as we're going to talk about today, thinking about bias, equity, and restorative justice and the ways we think about things with our criminal legal system and the broader space of diversion, we really, need to start in this, space very briefly, right, of the disparities in our criminal legal system, right, those disparities in sentencing, mass incarceration, and we have well documented at this point, lots of research around disparities in sentencing decisions and outcomes at both the sort of state and federal level, with BIPOC individuals being more likely to be incarcerated and to receive harsher and lengthier sentences than their white counterparts. Where we can walk backwards, through things like this, sense of the sentencing guidelines and recommendations. Obviously, the well-known example or well-used example, right, sort of the crack versus powder cocaine for decades, to the judicial discretion that exists, to the prosecutorial charging decisions, right, sort of which criminal charges to bring, how many counts to bring, based on the alleged conduct, coupling that with sort of the elements of charge bargaining and the whole plea bargaining system that we have, and not to mention, right, as we sort of walk even further back to the elements of arrest and referral for charges, especially when we couple that with the issues of sort of DMC. And so thinking about what we have in our criminal legal system is, each of the main state actors are discretionary decision makers who hold immense amounts of power, right? So, primarily law enforcement, prosecutors, and judges. Looking at law enforcement and prosecutors first with, law enforcement, this decision of whether to arrest at all. Or to issue a citation, what to arrest for and refer criminally, then to the prosecutors deciding, first again, whether to charge at all or to no process of referral from law enforcement, what charges to bring, what level of charge decision, being made, whether this is sort of a felony or a misdemeanor, especially when a person's alleged conduct can frequently meet the elements of several different possible charges and sort of their various lesser included offenses, along with things like, how many counts to charge, any enhancers to consider, et cetera, in these really complex spaces. And each of these decisions can ultimately play a huge role in looking at the possibility for restorative justice later on. I have another point sort of, starred on here, and that's because in some jurisdictions, there may be additional intervention points between law enforcement and the prosecutor's office, or, frankly, in collaboration with them in decision-making, where there may be a mechanism that exists either in sort of, some department or division of youth and family services or other relevant division in human services at that local jurisdictional level, who's also able to weigh in on when youth are arrested for certain alleged conduct, right? So thinking about this, the sense and the power of each of these discretionary state actors and making very important decisions at a bunch of different key points, right? So as shown on this sort of diagram, before I talk about where I see restorative justice, factoring into this sort of greater whole, and I really think we have to start at this point of talking about diversion more generally, right? Whereby each of these discretionary decision makers decides to move a person or a case along a particular path of our criminal legal system. In many jurisdictions and instances, you may have an opportunity to divert people out of the criminal legal system at the various off-ramp points, right? So these occur or can occur at distinct times from the space of, pre-arrest deflection all the way through post-plea, right? So post-charge and post-plea points where diversion is still possible. So at each of these points, the possibility for diversion may exist if the option is made available by the relevant system actors, again, or the people just sort of generally in power, right? State actors. So fundamentally, right, diversion is an option, right? So it may or may not exist as an option in any given jurisdiction. But, this too itself can even be a product of discretionary decision making, right? So whether it exists, where in the pathway it exists, what is eligible, and as we'll sort of come back and highlight a little bit later, who is worthy to offer an opportunity at diversion. And also on the last slide, you may have noticed that I had added a reference to some support staff and administrators because, as we talk about diversion, they too can be and become discretionary decision makers, right? So at each of these critical junction points, with each one of these different actors, right, there is and it becomes an opportunity for bias, whether conscious or unconscious, that impacts or that may impact a person's opportunity for diversion, right? So all the way from thinking about the different spaces that exist, right? The pre-arrest to post-arrest, where it's sort of, again, primarily law enforcement having the discretion or opportunity potentially at deflection or diversion, to the pre-charge space that exists at a prosecutor's office, to, again, support staff or program administrators that may evaluate certain cases or referrals that come into a prosecutor's office, to, again, evaluate things sort of pre-charge or post-charge, right? So thinking about this idea of then what space exists there, where you also may have things happen either pre-plea or post-plea, right? If it's post-plea, typically that is sort of paired with the deferred prosecution agreement, but all along this spectrum, right? As I would, I guess consider sort of the, 6-lane mega highway or super highway, there are all these sort of different off-ramp potentials that exist for diversion points. And those diversion points may be restorative justice. Like that is one option that exists in that total spectrum of the realm of diversion itself. Well, what does this look like, right? So the sense of what we're thinking about is the evidence of bias in diversion. And so we look at this globally, right, sort of nationally, but also globally. There is evidence of bias existing. And again, I don't think that's any surprise, right? There is more limited research for understanding that, but the evidence is still there. And that research is primarily with youth. So, looking at a few different points. So there's a 2019 Canadian study that looked at selection bias by police of youth for pre-charge diversion. There's also a more recent examination in England of youth and diversion, as well as a handful of other sort of smaller studies looking at youth diversion. And what they have all found, I think unsurprisingly, is that BIPOC youth are less likely to be diverted and more likely to be formally processed than similarly situated white youth. In the US, I'll say, more broadly, it can be a challenge to get at what this bigger picture analysis looks like, as most diversion programs aren't tracking and reporting the relevant information in a meaningful way that allows us to look at disparity and bias in diversion. These programs typically have policies that list factors for all referring agents to consider, but often a number of those factors are going to be highly suggestive and subjective. So in the research, some of the reasons given for denial of diversion were listed as things like, because a family can't be contacted, or a person is not able to be contacted or doesn't respond, which, while seemingly more objective, can be influenced by a number of factors, such as prior experiences and other potential participatory barriers, which we'll come back to later. Sort of another reason was sort of an individual or family was deemed uncooperative. Again, that's, somewhat subjective as we think about attitudinally, right, where someone is at. Another one has been reasons of because of a family's particular living arrangements or a family structure, that a person or an individual was deemed ineligible because they were viewed as less likely to be successful in diversion. Again, so looking at a family structure or a family living arrangement being a determining factor as to whether or not someone may or may not be successful or not. And the last one is really perceived attitudes of the individual and then their amenability to treatment. So I think if nothing else, this should raise some concerns, for us to think about, excuse me, regarding implicit and then certainly sometimes even explicit bias, as these sort of subjective elements can be impacted, primarily in ways by dominant cultural narratives of how different groups of people are perceived. And it comes back again fundamentally to this idea of like who is deserving or in need of treatment and leniency, and who is more culpable, right? Like who is more deserving of a second chance and who is more deserving of punishment or exclusion from consideration in this space. So turning specifically to RJ diversion, what brought me to this topic of bias and RJ diversion primarily comes from my involvement with numerous RJ programs, both locally but also nationally, and consulting a sort of programmatic examination for evaluation, where I've been asked, for guidance on things of how do we design or build a restorative justice program, or how do we make it, quote unquote, successful. Looking at all the things that are needed from sort of the buy-in of various key decision makers and those discretionary state actors, again, who, in order to consider restorative justice or RJ diversion, have to give up some of that power, right? Have to give up some control and power over those decisions and over the cases that are sort of before them, or things that are referred to them in the case of district attorneys' offices or prosecutors more broadly. So from that buy-in, all the way down to looking at the considerations of lists of factors for what a program structure looks like, where it's housed, how it's staffed, where, selection comes from, this idea of like, referral sources, because, like other diversion programs, most RJ programs do not get to choose who their participants are. And so just like all the rest, as we covered in the previous diagram, those selections of who is there and which people in which cases make their way over to restorative justice as an option are often made by, again, these other upstream discretionary decision makers. So when we look at a restorative justice program itself, we often don't ever know or even get to see what cases are referred, or why. And again, in the US, there's really never been sort of a broad study looking at that. But we have to ask, right? So where does a program get its referrals? And if then we're thinking about this idea of restorative justice, diversion, and the larger issue of bias and equity, if we come back to the space of sort of, is it immune? I mean, I think that's a really challenging question, right? Again, especially when we look at this idea of, case flow or case access and where a program gets its referrals. Quite frankly, when we recognize that there's very little control over what cases kind of flow in, you can build, as beautiful and as restorative a process as you want. That may be incredibly impactful individually, but systematically, it may well be largely out of your control what's there, what you see, or the impact that it's allowed to have. And it may have been that way since its initial conception, right? Even the way it was sort of designed, like all those concerns and thoughts that may have went in or may not have went into the decision to offer to have a restorative justice project or program, where it's located inside or outside a district attorney's office with a nonprofit or with some other space or agency. That there's a lot of things to sort of think about when we take into consideration, right, some of these elements of upstream determinants and concerns around equity. So if it's not immune, right, to bias based on the factors of the potential bias of discretionary decision makers, we're left with this question, asked by many concerned RJ practitioners of, well, all right, how do we prevent restorative justice diversion, restorative justice programs from replicating the same systemic harms as the traditional criminal legal system, right? If that's the goal, which I think it certainly should be. And for some, I think the response is simply that you can never have any sort of system involved connection. You can't even have, adjacent community-based restorative justice that has any interaction whatsoever with any portion of system actors, right? Police or otherwise. But, until we can get there, where people aren't calling police anymore, where people aren't being arrested or charged criminally, there really needs to be a way still, when we think about RJ and system connected RJ or system adjacent restorative justice, there needs to be a way to get people there, right? To get cases, to get individuals into that space, to allow people to have access to restorative justice processes, right? And so we need to think very carefully about both how they're designed and how they're structured, right? And ask some of these questions in thinking around, how do we prevent replication of harm, right? So when we think about racialized and gendered structural violence, as well as how we're attending to intersectionality of identity, and then the greater sort of overlaying of this intentional design when it comes initially here to design pieces, when we look at both selection and eligibility. So we can start in this space of thinking about, if we're going to address bias and if we're going to be addressing, the racial disparities that exist in our criminal legal system, for me, that means it absolutely requires intentional design with both a focus on and awareness of implicit and selection bias, and the knowledge that trying to rely on race neutral factors alone will not solve this problem. In fact, it may even make the issues of disparity worse, right? So there's a sense of like, is that going to be enough? Well, no, not likely, okay? And in fact, what we're terming, or what individuals may be looking at as sort of race neutral selection criteria, or as they view it, is probably not even race neutral, right? So even thinking about things like, prior convictions, okay, or first offender programs, and those sorts of eligibility selection pieces. Well, we already know what the system is good at and how good it is at getting convictions and getting contacts and the disparities that already exist in our criminal legal system. Okay, well, all right, so then what about things like prior arrests, prior police contacts? Okay, same deal. Well, if that's sort of part of your selection criteria, well, how does that account for, again, disproportionate minority content, right? Sort of DMC issues. Or what about they've previously received another type of diversion, right? This idea of worthiness, right? Sort of no second chances at diversion, okay? So these are some very common things that we might see. Well, all right, so if we have to move beyond those, well, what's next? All right, so what about risk assessments? Well, Risk assessments themselves can lack nuance. They often have lower reliability on BIPOC populations as they're not normed or validated based on design, and often find BIPOC individuals as higher risk and white individuals as lower risk. Okay. So there can be an incredible amount of artificial screening or filtering out of participants that may have started years before someone is even considered for possible participation in an RJ program, or quite frankly, years before an RJ program already existed, whether we're talking for youth or young people, or young adults, or all adults, right? The sense of it may be years or sometimes even decades if we're looking back at police contacts, if we're looking at juvenile history, if we're looking at arrest history, if you're looking at offense history. As you are looking at all of those things, we cannot look at them in isolation, and we cannot ignore the sort of structural elements that have led us to the spaces of mass incarceration and thinking about institutional or structural bias that has led to some of these results. So when we build programs that rely, in a lot of ways, I sort of see them as sort of faulty inputs, because again, they're not exclusive or actually race neutral criteria, because the system itself works in the way that it is designed and the way that it works. We think about what we know, and we don't pretend like these other elements don't exist as we're designing a quote unquote sort of neutral and new process or new program design. It forces us to take a step back and really strongly reevaluate some of the most common elements of selection criteria. And when we think about this idea of like we're building a program, even a program that's looking at this element of trying to address disparities that exist in our criminal legal system, that we need to think about and give good consideration to how are we addressing the factors that come before. How are we addressing the bias that exists at each of these diversion or discretion points? What are we doing about that? How are we taking that into account when we're thinking about this idea of what is the overall goal? What is the program attempting to achieve? Which of those things is it attempting to address? And then how is it taking into account, again, the rest of the things that we know? That even as we sort of see the positive results in the utilization of restorative justice and its effectiveness in addressing things like disparities, right, and racial disparities and disparate outcomes by its sort of very nature of being sort of more human focused, that considers sort of context relevancy and sort of individual circumstances, and looks at things in a more humanistic fashion. When that structure itself is based on all these sort of upstream determinants that themselves sort of filter through, we really can't cast that stuff aside. Okay, so the next thing is looking at this eligibility, right? And centering it squarely around participatory barriers and programmatic eligibility requirements. So some of the things that we see in different spaces is something that requires this idea of whether this is sort of a referral that comes from law enforcement or those from the DA's office, eligibility criterion of things like a reliable or verifiable mailing address, okay? Or are there upfront or ongoing participation fees? Those sorts of things, like those sort of, again, quote unquote neutral elements and eligibility criterion actually just sort of masquerade needs and social and economic disadvantage as legitimate criteria for participation. Okay, so that's sort of the first point. The next comes down to what I'll target as language, but in many spaces, it's referred to earlier as I sort of talked about this as like whether this is attitudinal or the subjective elements of deeming amenable to treatment, or for restorative justice programs, this sort of like demonstrating an appropriate level of accountability. In a lot of ways, sort of coding or masking what is being asked, and things that are very highly subjective elements of program design and selection criteria. And a colleague here at UW Law School, Michelle Levine, who had done a lot of work around language. And this sort of got me thinking about this in a very different way, where she was challenging the thought around restorative justice and this idea of, so quote unquote, the worthy participant, right? Like who has opportunity or access with restorative justice, and the concern that is raised, I think very legitimately, around language impairments, right? So Michelle again writes significantly about those impairments and in specific, the deficits in language and the ability to use it that exist at incredibly high rates among adolescents and adults charged with and convicted of crimes. So like I said, she really challenged me around RG processes in general, especially with young people who may not yet possess the linguistic acuity that a program or system may require for someone to take full responsibility for their actions, right? So that sense of how do you demonstrate an appropriate level of accountability, contrition, whatever it is that you're sort of asking about, or again, requiring as a program eligibility component when it comes to sort of accountability. How are we considering the ways in which language deficits or language impairments may impact who is or who is not eligible for this, especially when we look at, again, prevalence rates that exist in, again, the criminal legal system more broadly. So now, again, we fall into this area, as I sort of said, of intentional design. I'm going to talk about a couple other related pieces, right? So the first is around engagement. Because I've seen lots of different disparity levels of successful engagement. In other words, really just the idea of like higher rates of response and involvement of different populations of individuals. Referring to the previous sort of empirical studies, that is this element of who's able to be contacted, who has the successful elements that they need, whether again that's sort of reliable phone, reliable address, the things of contact that are there, as well as response and outreach and or response to programmatic contact, whether that's from staff or individuals. So I've got listed down here, right, even this sort of pure restorative justice, right? This is sort of looking at the broadest base of eligibility, meaning where restorative justice opportunity is a complete opt-in, right, where there's self-selection. So even an experience of an RJ process where someone can self-select out of the traditional system to opt in, right, self-select into a restorative justice program, meaning there's no referral source from any outside state actor or discretionary decision maker, where someone is purely their choice, right? Like they can just say, yep, I want RJ instead of this thing. Even in those cases, there has been observed disparities in successful engagement, right? In who chooses to engage in those processes, which can be results of elements of trust or lack thereof in systems generally, especially those that have repeatedly failed their communities, and especially those involving law enforcement or the courts, right? That sense of thinking about considerations around credible messengers, right? Who's doing outreach, or who's offering, or how is it described? Or again, does an agent of law enforcement or some individual who's ever doing the outreach, do they explain it differently to different peoples? Or, think about the ways in which their own biases is creeping in how much it's encouraged, right? Or how much they deem that person, sort of deserving of that piece, even when it's a completely open process for them, right? I've heard many stories of young people and adults thinking sort of RJ diversion is some sort of trick, right? This is too good to be true. It's not real, based on their prior experiences. A system or process like this, like what restorative justice does, really connecting at this human level, couldn't possibly exist, right? And I can't tell you the number of times that I've heard that from individuals, both those who, again, who've engaged successfully, that said they're really skeptical at first and sort of disclose partway through the process of what they sort of thought, as well as, the individuals who sort of opt out, right, are more hesitant or more wary of it. Then there's also going to be programs where you see disparity that exists in successful completion rates, right? So that requires, again, not only sort of this intentional design up front, but continuing intentional design and iterating around examination and reflection on successful completion rates, right? Examine what is being required. How is a person's success being determined? And fundamentally, like whether someone is being set up to fail about what is being asked of them. Again, in the previous webinar in this series, focusing on sort of the programs looked at and the research done out of Nebraska, again, asking and positing some very interesting sort of questions and research thoughts that I've had myself around that sense of use of surrogates, the use of direct victims. What are we seeing as far as outcomes? That there's a whole like wealth of additional research that's sort of needed to look at RG diversion, and specifically digging down or drilling down deeply to these elements of bias in these spaces. So that brings us to a point of critical reflection for really all of us, right? Or anyone who interfaces with these sorts of systems, anyone where there is sort of a local restorative justice program, where something like this exists, and we can ask ourselves, what does bias look like? Like, what are we seeing? What are you seeing? Is this occurring, right, in your restorative justice programs? Is this occurring in your systems? What are you identifying as both the causes of that bias, but then also what about the products, right? So does that exist in law? Does it exist, again, sort of locally, but that's municipally, or sort of at the state level, broader policies, or does it exist with sort of the program design? And then thinking about this idea of, what do we do about it, right? Like that fundamentally becomes sort of that issue. And, for many, I think it becomes about this idea of building a new conceptual model. Okay. First, looking at how do we look at it, right? So how do we track bias effectively in RG diversion, right? How do we then also get programs and system accountability when we find it, right? As I mentioned, sort of most diversion programs aren't tracking the data that we sort of need to look at it. So in ways, it's building into new programs or building into existing programs ways of collecting this data and then finding ways to meaningfully analyze it, right? So in some ways, right, it's looking at building new conceptual models for analysis of restorative justice itself. So thinking about other areas that we can look, right? Sort of like, where else may we see solutions, right? So asking yourselves as well, can design models from any other areas of the criminal legal system be applied to, to restorative justice diversion? So innovations in sentencing. We have lots of evidence and data about the effectiveness of restorative justice in the ways that it's been evaluated, and sort of looking at its metrics of success from again sort of recidivism to restitution repayment to satisfaction, from procedural fairness to outcome fairness to again relative levels of accountability, to looking at the various parties and elements. Well, what other ways can we look at it? And given that restorative justice itself has been sort of examined more critically, right, than the carceral system, right, than even the effectiveness of prisons, what else can we or should we be looking at, right, inside the criminal legal system, right? Is there anything else that we're sort of missing, that we're not thinking about? And then similarly, what about areas outside, right, of our criminal legal system, right? Looking at design elements for for this, like, where else should we be looking? Okay, so again, those are questions I'm not here to answer today, right? Like, this is a sense of thinking about where we start, and thinking about what we know right now. And as we sort of saw on a much earlier side, the answer is, when it comes to sort of the US system, not a lot. Again, we have to draw internationally to even look at this sort of issue more broadly, and then thinking about how do we look at this on a broader scale, in our own systems, right? And so whether that's local program analysis or looking at it more broadly, I think there's a lot of things that need to be considered. And then especially when we think about how programs get set up and designed, that really shift thinking upstream and how we address some of those fundamental concerns that need to be raised around engagement, around selection criteria, around eligibility, right? So that's, again, the main focus of thinking about, like, we don't control who comes to restorative justice, right? And so thinking about how instead do we make sure that we broaden the base of selection, that we have the widest sort of catchment area, that we have the ability to reach address and respond to the broadest segment of individuals? How do we, again, reach upstream? How do we get ahead of sort of the traditional system in our programmatic design to allow capitalizing on diversion at each of the discretionary points, while also thinking about what do we do to design new criteria? Okay. So that's fundamentally the point of today's conversation. I do hope, sort of open up the chat and the Q&A, that there are elements here. Okay, so I'm going to end my screen sharing and come back to this and look at the
So you
chat.
do have one question in the Q&A already. I don't know if you can see it. I just wanted to direct your attention to it. It looks like it's from Deborah Weissman. And so if you want to maybe jump in with that question first and then open it up for a broader discussion, that would be wonderful. Thank you so much for your presentation.
Okay, so let me put some Q&A. All right, so yes, Deborah says, you see more about problematic risk assessments or suggest some readings on the issue. Yeah, so the answer off the top of my head, Deb, the answer is I don't have those at my fingertips, but sort of looking into it, right, and looking into the data and sort of broader research base around risk assessment, sort of like what we know is just sort of these issues that cause sort of racial disparity, right? The sense of thinking about that we sort of know that they aren't like they're not designed for a broader population, right? The ways in which they were constructed is often missing some crucial or key elements once they start to get examined. And so, that idea of I see a lot of places and spaces asking like, well, how do we create a risk assessment, right? Like, well, I in some ways like to flip that question around and think about, rather than looking at risk, let's look at need, right? And what are you actually trying to address, and what are you trying to respond to? And so thinking about this idea of a risk assessment is what? It's a screening tool, right, to exclude individuals. So I instead like to think about, like, why are we asking this element, right? So for every single point of what would be deemed like an eligibility point or selection data point, we need to carefully ask the question of why. Why is this relevant? Why is this important? What value does this serve? Who is this potentially unintentionally or intentionally excluding, right, from that selection? So that's the sort of thing is we know that they're not perfect. I see a lot of places sort of looking for some. When I try to look at sort of even the broader base of research tool, a lot of these assessments themselves are locked behind paywalls. They're locked, again, sort of exclusively in sorts of different studies. And then you'll like read other articles that look at those risk assessments themselves, and they talk about, oh, this is how this one is flawed, or this one, how this one is biased, so here's what it's sort of missing, or here's what it's ignoring. So like, I've not seen a perfect one, right? Or one that I would be like, this is the one to use, because I think that there are so many potentially fraught elements that go into that. Like I said, where I think we spend a lot of time coding in, again, whether it's race neutral terms, elements that themselves cannot be determined or I think appropriately separated from that space. So that's why, again, it gets to the point of like, who can we serve, or what can the programs themselves serve? And when we think about it instead as elements of need, what is appropriate for that program in sort of meeting those needs, but not artificially excluding things, based on a lot of those, again, very common criteria, because restorative justice is different. And that's the thing is we're forgetting that in a lot of ways, right? When we just utilize it in the same way that every other element of diversion is utilized, we're missing the point, right? We're missing the sense of the value that restorative justice can offer when it comes to being something different than other diversionary mechanisms or diversionary spaces. I would say I could talk a lot more about that, but I'll I guess move on to the next question. Okay. See, considering RJ programs across the U.S., what are some of the most notable programs, either for the successes or challenges? So I I'm not going to specifically put any programs on blast as far as like, here's what I think they get wrong. And I really, again, would want to speak more in generalities. I think some of the more problematic elements become these first offender programs, right? That one is a big one, right? This idea of missing the point of restorative justice, which is sort of about like being in the business of second chances, sort of saying that right, if they've been offered another element of diversion, or they've been given an opportunity at this, they're never going to get another chance, right? This sense of people are going to take advantage of this, and ignoring the potential for human growth, ignoring that potential for what is a previous experience with systems and system actors been, right? When we need to work from a space of building trust and successful elements of engagement, that may in some cases mean individuals who have never found trust or accountability at the system level, right, from systems, and instead been harmed by it. A lot of times they're going to look to test restorative justice systems in the same way that would look to test others. So thinking about, those pieces, like what is problematic, I'm going to see it's going to be around those, or very narrowly limiting which offenses can be looked at, because those often come from elements of comfort, right? Like, what is the system comfortable with, right? What is okay, right? What is deemed acceptable, right, by whether it's law enforcement or prosecutors or other sort of system actors or agents who, again, are being asked to give up some element of power and control over communities or over individuals, and allowing or empowering communities to solve their own problems, right, to address the own issues and harm and crime that has occurred there, looking at having to satisfy those comfort levels, especially when those are the very same spaces that programs are relying on for referrals, right? So like I said, you can set up and you can design a beautiful program. If you don't have that sort of trust and buy-in, it's not going to be successful, because you won't see the cases, you won't see the referrals, and it's not going to have the impact that it can. So the programs that I would sort of see as having the most potential for success are going to have sort of the fewest eligibility criteria, are going to have the fewest restrictions on who is able or deemed, worthy of participation or worthy of getting an opportunity at restorative justice. Those that have multiple entry points that start, again, all the way at the pre-arrest space, to allow these different mechanisms that aren't relying on someone else downstream to catch it, right? That at each point, like, there's sort of a narrowing. And each further point we get into a system, sort of each person who reviews it, each discretionary decision maker, is relying on the legitimacy of that previous discretionary decision maker, that they're like, if it's here for a reason, right? Like, if this was meant to be diverted, or if this was an appropriate case or an appropriate individual for diversion, certainly that would have been caught by some sort of upstream actor, right? Whether that's an individual officer or an individual law enforcement agency, or then we get to an intake worker, or we get to, again, with youth, whether that's sort of screened by a social worker or screened by some other agent, or a program person for evaluation, or even at a prosecutor's office, where every single case that meets XYZ criteria, whether that's sort of age or offense range or whatever, that there's sort of second and sometimes even third or subsequent looks at it, with sort of fresh eyes and fresh asks about, why is this not eligible versus, why is this eligible? So in a lot of ways, it's about sort of flipping the routinization and flipping that conveyor belt that instead sort of works from the premise of eligible, rather than sort of cherry picking cases that become eligible for restorative justice, instead finding very clear justifications as to why not. Right, that don't just sort of rely on the subjective, well, because I don't really like their family structure, or, I don't think that they're amenable. What does that mean, right? The other thing is, again, sort of having some of that information and selection criteria public, because what I will tell you is that often those are internal documents, right? That selection criteria is not necessarily open when it's even an outside agency, right? So even if you have a nonprofit, non-system actor service organization providing or running a restorative justice process, right, or restorative justice program, they may not even be privy to what the selection criteria of the referring agent or agency is, right? Or there may be sort of shadow criteria, right? Like here are the ones that sort of are generally acceptable, like these are the ones that we sort of agreed publicly, but there may be some additional, right? And those are the ones we need to sort of ask questions about and asking for justification as to why not, right? Like why aren't we sort of seeing these cases? That's a sort of problem area, right? Like it is a little bit of the point that we can't know what we don't see, as I sort of referred to earlier, is a restorative justice program doesn't know what cases they don't get, right? They only see the cases that they do get. They might see them on the news, right? Or they may see them, right? Yeah, well, that ends up in court. Or you may have a parent call, or you may have, an attorney call. You have some other interested community member call about, hey, why didn't this case get into a restorative justice diversion, or why wasn't this seen as appropriate? But that's not their call to make often, right? Like that again is made by the sort of upstream actors, like the person once you get to the level of the diversion program or restorative justice, whether internal or external, often that information is not available. Okay. So next
I'm putting the questions both in the chat, but could you read it aloud? We had a request to read it aloud as well. Thanks.
Yes. So should this rebuttable presumption of eligibility be an explicit part of the design model? Why or why not? I mean, I think I've talked a little bit about it, that I think that's idealized, right? I think that's the sense of it will open it up as much as possible, and I think it would go a long ways, frankly, right? But then it actually can't just be this presumption on paper. It can't just be written as part of the elements of program design or an MOU, or some document that's only looked at by a few people. Instead, it has to get routinized. And what we sort of know about systems, even when restorative justice or diversion offers a relief valve, right? Like offers the solution that is being asked for by many offices that are overworked, that are overburdened by having, too many cases and not enough prosecutors or not enough sort of staff to handle. What we see is not more cases go to RJ and greater levels of critical thinking. What we see instead is that there's it's deeper entrenchment in the processing, right? It's easier just to move the case along on the conveyor belt to the next stop, to the next person, to the next step, because frequently the system actors themselves may not even have the time and space to appropriately consider, right? To think about all of those sort of factors. So again, I think, yes, it should be an element and an explicit part of that design model, but we need to go beyond that and then creates mechanisms for that to happen. Because again, the busier someone is, the more likely, if their day-to-day is processing cases, if their day-to-day is about just sort of moving the things through, right, at the individual sort of prosecutor level, or intake, or you do it a initial appearance and it just sort of moves along, unless there is also, again, sort of some elements for continual review and some individual with the time and space and ability that says, hey, wait a minute, like, let's look at this kind of at each space and ask those critical questions. It is likely not going to happen, right? So that's where, I mean, it requires in some ways this sort of, fundamental shift in process, but then also a fundamental shift in time that requires maybe additional people, but additional elements, right? So that's what I'm sort of saying, like the more points that we can have that exists, right? Sort of looking at every single one of those points, right? From pre-arrest, whether it's deflection, to direct referral from law enforcement, to post-arrest direct referral to law enforcement, from law enforcement to restorative justice programs, to again, a screening agent, to any case that sort of comes through to a DA's office. And what they're deciding to do, like, what do we do with this sort of case? I'll look there. Then if it gets assigned, past that screening mechanism to the person, then that needs to be sort of like policy and procedure that exists within the individual prosecutor's offices themselves. Like, this is just part of our review process. Whether was this examined or screened for restorative justice? And was it done meaningfully, right? Then again, similarly, as it gets to that sense of beyond that, is there a sort of a second look when it gets to the point then as well, like it gets in front of a, again, sort of the intake person, right? You get to initial appearance, whether that's done in front of a court commissioner or this is done sort of right in front of a circuit court judge, looked to or asked about at that sort of space, right? And thinking about empowering all elements of this to continue to sort of take additional looks at it. But again, never sort of saying like, well, I'm just going to rely on someone else to catch this down the road, or like, we can always kick the can down the road. Well, that's going to be a decision I'm not going to be holding the bag. I've seen that with the space, even where law enforcement agencies have an opportunity to direct refer, if it doesn't become an explicit part of their process, right? Their own sort of screening sort of rubric or metric and how their case flow model works, then we'll just sort of say, we'll let that for the prosecutor's office to actually determine, okay? So again, there are the things that I see when they aren't explicit, when they're not a deeply ingrained part of this, that it does, it's sort of like kicking the can down the road and it's someone else's problem or someone else's responsibility to look at, is this person appropriate? And where that comes from often is out of fear, right? The sense of like, in the event that this sort of goes wrong, right? Then who's going to be there sort of caught holding the bag, like who's going to be deemed sort of responsible for a case or an individual that doesn't go right, where it's not successful completion, where it winds up back in the criminal system, or if there's another offense that gets committed or something, more serious that happens.
There's two more questions in the Q&A. I wonder if you could pick the first one about questions.
Yes. So this question is, what questions would you ask if you were interviewing for a chief prosecutor position, if you had the chance to ask them anything? Wow. All right. Knowing they'd be the one to decide in our jurisdiction who is eligible for the diversion restorative justice program. All right. Let me think about this for a second. I'm going to flip this a little bit, or I'm going to come at this a little bit sideways for this what question would I ask? I'll say the first thing I would ask, and this I'll give a bit of the anecdote, is whether this person has ever been in prison before, right? Have you ever visited a prison? Have you been to the correctional facilities in your state or your jurisdiction? Do you know what happens and what exists at sort of the various levels of of incarceration, what programming is available? Because I can tell you from personal experience in one of these serious and sensitive harm cases, so a homicide case, where a person's support person happened to be, a district attorney in a different jurisdiction, so that, no relevance to the case, like they just happened, right, also to be a prosecutor. When we got to that prison to do this restorative justice dialogue, that prosecutor told me that they're like, this is the first time I've ever been to a prison before. Like I send people here every week, but I've never actually been to one. So that, frankly, I would think really should be a job requirement, right? To know what does it mean to enact your duty otherwise, right? Like, what does it mean to go about the business of the criminal legal system and send someone to prison, right? So that's sort of that first question. To think about like, do I think about diversion differently? Do I think about what needs are different? Do I think about things at sort of the county community level, or how am I viewing it? Okay. So that's, I think, sort of the first thing. The next questions that I would sort of ask is, how they're viewing it, and if they're sort of viewing it politically, right? This idea of, what do they think about restorative justice? What do they think that it can accomplish? How do they see it helping them, right? Whether that's sort of publicly or privately. I would ask about how they could see themselves, like, how do you see utilizing this to help your own office, right? To help reduce the number of cases that sort of come through here that frankly, many of them don't need to be there in that space. So engaging in that sort of broader talk around diversion or deflection generally, but then more specifically understanding, like figuring out what do they understand about restorative justice and what it means and how that process might work. So the second part of that question was, so knowing they'd be the one to decide in a jurisdiction who was eligible for diversion and restorative justice programs. So that, I think, implicates these foundational pieces, right, around restorative justice. But a lot of it becomes sort of, self-reflection, who's going to make those decisions, and sort of at what points. I'd ask them, again, what are they comfortable with? The next thing to ask them is, what are you not comfortable with? And then why, right? Always asking why, right? So again, as they're determining those things, like, what do you think is appropriate, and then sort of why, and then what do you think about this, and providing examples of sort of successes in these sort of different spaces, And then also like how quickly can we grow? How quickly can we evolve beyond our initial list of eligible cases or of eligible individuals, that sort of thing. Because that's going to give you a sense of where you can go and grow and how they view control. I think the next sort of related critical piece is understanding like how do they view their role, right, as vis-a-vis the community? How do they view their role as in like what is the chief function of their job, right? Like what are they there to do? What do they view the role of prosecutors as? In thinking about this idea then of like how are they viewing individuals that come through? How do they see sort of issues in the community, or how do they see themselves? Do they see that they're the ones with a monopoly on justice, right? Versus a sense of like, do they think community is able, right, to address things that exist within community? So I think there's that. I would probably have another sort of broader list, but those are sort of the things philosophically that I would want to get at with a list of probably more targeted questions than that. Okay, next question. Given your reflection a moment ago about how individuals may not have the space to consider alternatives in processing cases, would it be fair to say that the reflection necessary for shifts are inherently inefficient and otherwise unattractive from a programmatic standpoint? Okay, I need to read this second twice for myself. Let's see. Given your reflection a moment ago. Alternatives necessary for shifts. Okay, so shifts in that are inherently inefficient and unattractive from a programmatic standpoint. Yeah, because we're coming down to this idea of like a resource of time. Okay, but when we think about this idea of making that a part of someone's calculus for their role, ultimately, if you're going to have less cases, if you spend this critical time thinking about this upfront of what needs to be here, if I can recognize like, wow, if I can, spend the time thinking about these 10 cases and which 3, 4, 5 of them might be appropriate for diversion, might be appropriate for restorative justice. And then again, letting the restorative justice like process do its thing and letting them determine what they think in the program pieces of that, then you recognize actually that it's not inefficient, that ultimately you have more time and more space to deal with the cases that you may need to spend more time on and actually sort of litigating, right? The fact that we have 90% plus cases that result in a plea, result in some sort of settlement, the cases aren't necessarily going to trial, that they rely so heavily on this idea of of card bargaining in the sense of ways in settling cases, that ultimately you can achieve some of the same sorts of results of cases sort of being finished or concluded, but with much different and healthier and more satisfactory results from what we know empirically, right? So it's that sense of you have to see the benefit of what can this buy you, right? It's the same thing of asking questions in school and they're looking at implementation. They're like, well, we don't have time, we don't have resources. Well, I fundamentally asked them like, okay, so what percentage of teachers do you spend on dealing with conflict, dealing with disputes, dealing with things in your classroom? And they tell me, well, 40 or 50% of their sort of instructional time is actually spent on dealing with conflict or things that arise in the classroom. Okay, well, so then that actually means you're spending 40 to 50% of your budget on thinking about, this idea of you're spending time there anyway, when like you could divert and shift that in a way that can be actually much more efficient when it's looking at what is more appropriately belonging in this space versus what shouldn't be here. All right, the next question, this is obviously the last one given sort of our time.
It was actually a comment.
Oh, just a comment.
So I went ahead and put it in the chat for everyone. Thank you, Ted Lewis, for putting that comment in there. I actually want to perhaps invite your final reflection, Professor. We're sort of at our time, and just invite others to think more critically about this context. I know we've had some thank yous already appearing, so I appreciate that. But if there's anything you want to leave us with, that'd be wonderful.
Yeah, I mean, I think that comment is spot on, right? So, that element of default referral processes that highlight that, right? That's sort of what I'm pushing for, right? That sense of how do we flip things, right? So the sense of like where the routinization becomes like this is how we're looking at people, right? That we look at them different, and that fundamentally changes the role of prosecutors. It fundamentally changes people's jobs, right? The way that they go about sort of doing business, and hopefully reduces the need for the over sort of burden system. And we think about these sort of efficiencies or inefficiencies that exist, and just in sort of like processing cases, the way that we process them is incredibly expensive and inefficient themselves. So yeah, it requires more education, it requires sort of more thought and research in this sort of space. But it also requires more openness for vulnerability and for discussion around elements of discovering bias, of discovering disparity. I think a lot of times that why we don't see data recorded, why we don't see data reported, is so that we can potentially ignore a problem that exists, right? So if we sort of don't intentionally know about a problem or know about it existing, then we don't necessarily have to do anything about it, or we can just sort of, again, continue doing business believing that we're doing it the right way, rather than critically analyzing what we're doing and then never stopping, right? We can never settle with where we're at. We need to continue to be pushing forward and continue to critically examine our assumptions, critically examine our criteria, critically examine our outcomes. That has to be part of our jobs. It has to be built into our programs. It has to be built into our grant proposals. It has to be built into all the ways in which we think about programmatic evaluation. Needs to be there from the front end. Or, yeah, we are going to continue doing the same things. That restorative justice won't be different if it doesn't get treated differently, or if we don't act or respond differently, to make sure that we're not falling for that trap of replicating the systemic harms that exist. Even when we get great outcomes in restorative justice, you know what? We can still do better. So I want to just have push us forward, right, in that way. So push me, challenge me, reach out to me. I'm here. I love engaging in this thought. There's multiple places around the country currently that I'm working, and I'm always looking for broadening that that thought analysis. So thank you very much for having me. I really appreciate the opportunity.
No, great, and we appreciate that you end us with that provocation, that we can all be looking at this more critically and always do better in all the ways in which we're working within and outside of systems. So thank you for joining us, everyone, today. The session has been recorded and will be available, and I hope you do join us on September 20th for our next one, where we're going to take a deep dive into programs in 2 different states, as well as potentially in person at the ABA criminal justice section meeting, and perhaps you will be there, Professor Shar, as well. So take care, everyone, and have a great afternoon or morning, depending on what part of the country and world that you are in.
Thank you.